what I wanted to try to do this morning was, because of the presentations that are coming afterwards, I wanted to kind of set the platform for the discussion that is going to come with Joanne's presentation and the more detailed presentations from the Integrity Commission and so on, by really interrogating the issue of why this integrity and accountability issue is important. And the reason why we know it's important is because of the problem of corruption. And so if I wanted to explore in some detail the question of corruption, what it is, what do we understand by corruption, how big this problem of corruption is, how it occurs, what are its effects, and then what are some of the things that can be done about it. And that will speak to some of the particular kind of legislative and other measures and so on, which we know we are struggling with to try to deal with the problem of corruption in the Caribbean. So to the question about what is corruption, the traditional definitions speak about questions about, it's really a perversion or destruction of integrity in the discharge of public duties by bribery or by favor. And the Transparency International has a rather more terse but very apt definition. It says that corruption is the abuse of public or private office, okay, so it applies not only to the public sector, it also applies to the private sector, for personal gain, or the even more cryptic and forceful definition, the abuse of entrusted power for private gain. And that notion of trust, we'll see, is a critically important issue. And it applies particularly in the context of people who are serving in public life, the question of trust. But the contemporary understanding goes beyond questions of bribery, goes to abuse of power, to conflict of interest, to patronage, to nepotism, to theft of state assets, diversion of state resources, insider trading, illicit enrichment, money laundering, providing advantage or preference. All of these things fall within under the rubric of corruption or activities which need to be discouraged, and which then speak to the questions of integrity and accountability. And there are different kinds of corruption. We know we talk about grand corruption, petty corruption. There is political corruption, which is a very interesting and important notion. Political corruption, the manipulation of policies, institutions, and rules of procedure in the allocation of resources and the financing of political decision makers who abuse their position to sustain their power. Political corruption. So we have a very expansive view of what corruption means and what it applies to. But to come back to the central idea put forward by Transparency International, the abuse of entrusted power. And so therefore we can therefore speak to the question about trust and where we're located. I have a little sort of diagram there. So we talk about who are the people who might be affected: the public, investors, depositors if you're a bank, or policyholders, and so on if you are, right? And then you have somebody who is in a position, they are holding a particular office. And that office entails a position of trust. So in the last session, you talked about the questions of the fiduciary duties of a director. The word fiduciary comes from the Latin word fides, which means trust. So it's really about trust. You are put in a position of trust, which means that you have to be pursuing an interest which is not your own interest. It is the interest of somebody else, the public, the investors, the depositors, the policyholders, the case may be. And then what happens when people are put in positions of trust? They have a duty. So from the time you are put into a position of trust, you have a duty. There's a corresponding duty that goes with being put in that position of trust. And those duties, which we talked about last week, and I'm quite sure we'll talk about again, are outlined in law and in the common law: duty of care, the duty of loyalty, the duty of confidentiality. But what happens when people essentially breach that duty. When they breach that duty, through their conduct, in other words, people must they must either do something, or they may fail to do something, and this is important as well. So corruption may occur not only when somebody actively does something, but also when the duty that they are supposed to discharge, they fail to discharge that duty. So it's about doing something, or it is also about sometimes not doing something. So the conduct of the individual who is in that position of trust leads to harm. It leads to some kind of adverse effect or impact on the very public or investors or depositors or whomsoever that you are supposed to serve. And that, in essence, is how we want to think about the whole problem of corruption, right? But to go on further, in terms of the question of harm, we talk about conflicts of interest, where when you are in a position of trust, it means that you have to set aside your personal interests. Whatever personal advantage or gain that you may have from the position that you hold, you've got to set that aside. And where you're not doing that, you get into what we describe as a conflict of interest, where your private or personal interest begins to influence the decisions that you make while you are holding that office. And there are different kinds of conflicts: self-dealing, influence peddling, where you are using your office to influence something somewhere else, the use of state property for private gain, accepting benefits, using confidential information because you are in a position where you are getting certain kinds of information which needs to be kept confidential. But instead of doing that, you use that information either for your gain or for the gain of your friends or your family, and so on as the case may be. Or you have outside employment. How many times do we hear about people in public office, whether they be policemen or they be whatever, having some kind of employment outside of their public office and duties? And then the harm that may result from corrupt conduct, including higher costs to taxpayers, higher prices to consumers, the deprivation of goods and services which may be diverted elsewhere, and threats and psychological pressure on people. So there are all of these things which come into the question of harm, the question of how your conduct as a public official adversely impacts the people who you are supposed to serve. The problem of corruption is huge. It's a big problem. It's a problem everywhere, quite frankly, but it's obviously a problem that is more significant in some places compared to others. The United Nations, for example, estimates that corruption costs about 5% of global GDP, or $2.6 trillion. This is a fairly old estimate. This estimate goes back, I think, about 5 years. The World Bank, which has the United Nations STAR initiative, which is the Stolen Asset Recovery Initiative, estimated that criminal activities, corruption, and tax evasion account for $1 to $1.6 trillion each year. Each year. Criminal activities, corruption, tax evasion, $1 to $1.6 trillion each year. Developing countries lose $20 billion to $40 billion annually to corruption. And the World Economic Forum estimates that corruption increases the cost of doing business by 10%. Right? So, and there are many examples that we have seen about presidents and prime ministers and so on, who have literally stolen money from their countries and ended up living in other places. So we have the Transparency International scorecards, Corruption Perception Index, which I think is going to be discussed in the second presentation in this session today. And where we are, I just selected some of the countries and where countries are. So at the top of that list, you have a certain set of countries which are consistently in the top 10. The Norways, the Singapores, the Netherlands. Interestingly, the United States of America, and this is looking at the change between 2012 and the latest one, which is 2019, and the United States has dropped significantly. They've dropped from about position number 17 to position number 23. Very interesting. Barbados has also declined, which is something that I think one would need to interrogate. I can't say that I necessarily perceive that myself in terms of what's happening in Barbados, although we know that there was a very high profile case in Barbados, which was concluded very recently. Jamaica has come up in the rankings. Trinidad has dropped in the rankings. Guyana has risen significantly in the rankings over the course of the last 6 or 7 years. And then you have a country like Nigeria and other countries in Africa, which continue to occupy the bottom of the table. So in terms of the Caribbean countries, at least the larger ones, Barbados, Jamaica, Trinidad and Tobago, we see some different kinds of movements. But in the case of Trinidad, we have in fact declined. Now, the question is, how does corruption occur? It is facilitated by people who have close personal relationships. It could be family, ethnic, or political party connections or ties, by greed, by weak governance. In other words, there is opportunity. People perceive through weak governance that there is opportunity for taking advantage of systems. Inadequate legislation, inadequate capacity to enforce, and I'm quite sure we'll have a significant discussion about that later on. Weak enforcement of laws, even where there is capacity, and immorality. And corruption tends to be attracted to large infrastructure projects. You're building big airports, or you're acquiring equipment and ships and so on and so forth, or oil and gas projects, or projects requiring government permits. Those are the kinds of projects to which corruption tends to be attracted. And it is done through bribes, kickbacks, bid rigging. We have that ongoing investigation taking place in Trinidad now in respect of a state enterprise, which clearly involves bidding. And I say clearly because I happen to have seen the board minutes in respect to that particular situation, that particular enterprise, a very clear case of bid rigging, which is now beginning to go through our courts here. Inflated contract sums, right? So all of these are the methods by which corruption tends to occur. This is talking about grand corruption now, because in terms of petty corruption, we're talking about things like grease hand and paying a customs officer or paying the licensing officer and that type of thing and so on. What we want to focus on here now is on grand corruption, where things are done on a large scale, which may involve parties conspiring and so on, as the case may be. And how do the people who engage in corruption, because at the end of the day, they have to move the money. And as those of us who are involved in financial institutions, whether in banks or insurance companies and so on, know, because we have to be trained annually in money laundering practices, whether you're working as a director of a bank or the staff of a commercial bank or an insurance company, to understand how money laundering, which is key to corruption, how that takes place. There's not a forum to discuss that, but basically it involves essentially three things: the placement of money, dirty money, moving into a financial institution or a mechanism for moving money. It may sit there for a while and then it moves on. Layering, which is where the money moves overseas to some overseas bank or offshore company, and then integration, where those funds are then used to buy what are legitimate assets. And we can talk more about that. So essentially the economic and social effects of corruption, it undermines the rule of law. And I say that because you have situations where the scale of the corruption is so large that it makes sense for those people who are engaged in that activity to actively undermine the institutions which are set up for investigation and enforcement and adjudication in these matters. Let us not fool ourselves. Let us not fool ourselves. When these activities take place on a significant scale, it makes sense for the perpetrators of these acts to suborn police officers, to suborn people in our integrity commissions, to suborn people in our Office of the Director of Public Prosecutions, and to suborn people who are in the judiciary. Let us make no mistake. So what you have is an undermining of the rule of law in a society. And when we talk about people who are presidents, prime ministers, government ministers, who are in themselves positions of power, leaders of state enterprises and so on, who have not only power, but access, and who have standing in the society, then that facilitates this undermining of the rule of law. It depletes national wealth, it promotes inequality, and it damages the fabric of our societies by essentially by lowering the trust in our institutions and in our political leadership. So these are some of the effects that we have of corruption on that scale. So the question is, what can be done about this, or what is being done about this? And there are initiatives which are taking place at the international level. The various conventions, international cooperation in terms of enforcement. There's the question of improving governance and enforcement at the national level. And then there are specific things such as whistleblowing, procurement regulation, and ethics training. But essentially, it comes down to four things: prevent, pursue, prosecute, and punish. Now you've got to do all four. You have got to do all four. You've got to prevent, you've got to pursue, you've got to prosecute, and you've got to punish. And we will see, as we talk a little bit about our experiences in the region, to what extent we have been successful and why we are where we are in the CPI rankings when we look how we stack ourselves up against those four things. Now, there's the United Nations Convention Against Corruption, which goes back to December of 2003, with its four pillars of prevention, criminalization and enforcement, international cooperation, and asset recovery. There are significant European initiatives, some of which we are complaining about now in respect of the money laundering, the blacklisting of some Caribbean countries, and so on. There is international cooperation initiatives such as the Mutual Legal Assistance Treaty, to which one of our countries are party, and that works through the Office of the Attorney General. There is extradition, which is of questionable effect, as we see at this point in time, of trying to people to extradite people to other jurisdictions to be able to stand trial. And then, importantly, the question of stolen asset recovery and the freezing and confiscation of assets. So there are all of these initiatives. Now, in terms of domestic legislation, we have things like the Prevention of Corruption Act, the Proceeds of Crime Act, POCA, the Financial Intelligence Anti-Money Laundering legislation, bribery legislation, the UK Bribery Act, which I think is of 2009, very powerful piece of legislation. The United States has the Foreign Corrupt Practices Act, and I'll talk a little bit more about that in a second. And the RICO Act, the Racketeer Influence and Corrupt Organizations Act, which the United States uses both the RICO Act and the Foreign Corrupt Practices Act to go after a lot of people. They use these methods as well as the Internal Revenue Service in the United States. The United States is used extensively to track down and to deal with issues around corruption. Integrity in public life legislation, whistleblowing legislation, procurement legislation, and of course, freedom of information legislation. Now, in the course of the CARICOM, we do have model legislation in respect of several of these issues. So, anti-money laundering, those of us who are in and around financial institutions as directors or staff know these very well. We've been doing them now for the last maybe 10, 15 years or so. KYC, know your customer, enhanced due diligence, designation of people as politically exposed persons or PEPs, software to detect multiple deposits and sweeping of deposits. Whether you know or don't know, our banks have now, I think all of them, implemented fairly sophisticated software that allows the bank to detect suspicious activity and to make suspicious activity reports, SARs, or SARs as we call them, back to the Financial Intelligence Unit. And that is done through fairly sophisticated software that would allow the bank to identify somebody trying to go to multiple branches to put different amounts of money in and so on. Capture all of that information and send it on. software to detect suspicious wire transfers, so that we are using technology, we are using artificial intelligence technology now to be able to identify a lot of these transactions to try to stop money laundering. I want to spend a little bit of time, not too much, but a little time on the Foreign Corrupt Practices Act of the United States, because you would realize that in many instances where people have been actually caught and prosecuted for corruption, it has been done not by us in the Caribbean, but it has been done by the United States. In the case of our Piarco Airport matter, which we could probably talk about at some point in time, the foreign participants in that were convicted, were prosecuted, convicted, jailed, and released in the United States already. Whereas the Trinidad and Tobago persons who were alleged to have participated in that are still to face the High Court here in Trinidad. But how does the United States do this? The United States does it because their act defines something called interstate commerce, which is the movement of anything, that is goods, money, emails, text messages, and so on. And of course, the money center banks sit in New York. So that if you are sending money to Switzerland or to Zimbabwe or to Argentina, 9 out of 10 times those funds pass through a New York bank or a money center bank, which is a US bank. And once it passes through there, the United States claims jurisdiction over that transaction and can prosecute people who are involved in that transaction. Extremely powerful, and they have used it to deal with a lot of corrupt practices for people who are not American citizens at all. They may be Trinidad and Tobago citizens or Jamaicans or Bajans or from anywhere in the world, but they can use this very, very effective piece of legislation to be able to do that. Whistleblowing, whistleblowing is, whistleblowing is something which we don't have that here yet in the region to any significant degree. At least I've not seen legislation on that. We've been talking about it, but whistleblowing is extremely important in uncovering corruption wherever it occurs, but you need to have proper protections for people who are whistleblowers. And in some places, for example, in the United States, whistleblowers are significantly rewarded for when there is a successful prosecution for a corrupt practice or a criminal act that is successfully prosecuted. The whistleblower himself can get a lot of money from doing that. In respect of
I'm not sure if
public life legislation, we have that in the region. It talks about, sorry?
Your screen had frozen, Dr. Farrell, so I wasn't sure what had happened. Please continue.
So I'm on the screen promoting integrity in public life. And I'm saying that we do have that legislation here in the region. And the Barbados legislation, which is only now coming into place because they have, I think it's passed the law house in Barbados, it's now going to the Senate. Jamaica has legislation on that, although their legislation is very circumscribed. It applies only to parliamentarians. In our case, in Trinidad and in Barbados, the Barbados proposed legislation, it applies to a much wider group of people in public life. But I think we're going to interrogate that a little bit later in another session. Procurement legislation, major source of corruption and bribery. We are seeing legislation coming into play in the region. In Trinidad, quite famously, our legislation is yet to be properly proclaimed, although the regulator is set up and ready to go. And So just kind of, this slide just gives you a kind of a picture as to what legislation is currently in place in the region. Prevention of corruption, proceeds of crime, yes. Financial intelligence, yes. Integrity in public life, yes. Extradition, yes. Freedom of information in a couple, Jamaica and Trinidad. Procurement in Jamaica and in Trinidad. But we don't have as yet whistleblower legislation. I'm subject to correction here. And neither, although it's been promised, do we have illicit enrichment and non-conviction based asset forfeiture. This is the so-called famous explain your wealth legislation, whereby if you have somebody who is in public office who looks to have assets which they cannot explain, then you can in fact seize those assets. Now I know that that legislation has been promised in Trinidad, but we are yet to see it implemented. But more than legislation, enforcement is important. Legislation must be supported by strong police capability for detection and witness protection. And this is a problem, right? I'm not going to go into that. In my view, it is a problem. It must be supported and enforced by fair but speedy court processes. In the United States, for example, if I'm bringing a case against somebody, that case must be brought to court within a year to 18 months. It has to reach the court door within a year to 18 months. We have had preliminary inquiries going on in Trinidad in respect of matters which have been going on for 16 years in the magistrate's court. We need appropriate sentences on conviction. We need to have confiscation of assets, repatriation of funds from overseas, compensation or reward for whistleblowers, which I talked about. Now, I just want to highlight the Singapore situation, because Singapore is a very interesting country. That's why they're at the top of the CPI list.
Okay, so it appears that Dr. Farrell's screen has frozen again. Hopefully it will right itself.
Lee Kuan Yew set up the CPIB. All right. Are you hearing me though?
Yes, we're hearing you now.
Okay, and is it on the screen is more than legislation, enforcement too, right?
That's right, and we were hearing you as you went to Singapore as the example.
Right. So in the case of Singapore, I'm saying Lee Kuan Yew set up the CPIB very early in life and in the life there. And the interesting thing about the CPIB is that he mandated the CPIB to investigate anything and everything and everybody. From the Prime Minister down, nobody was exempt. And they deal with cases regardless of people's rank or status. They will investigate and they will jail the person who bribes as well as the person who receives the bribe. And this is one of the reasons why Singapore has been so successful in essentially eliminating corruption in that society. And then finally, of course, I'm saying legislation is important, enforcement is important, but we also need to have two important things. But one is what I call aligning interests, which is to say that the interests of public officials and the state have to be aligned. What that means is that when people are invited to do public service or invite themselves to do public service because they run for elected office or something as the case may be, they must have an understanding. They must be clear and have an understanding about what it means to be in public service. And that they're not there, they must understand the whole concept of fiduciary duty. They must embrace that they're not there for themselves. And they must not simply say it, because all our politicians say that they're all about public service and so on. And then something else happens, okay? But the state has to articulate the public interest and indicate the behaviors that it prescribes by means of anti-corruption legislation. And the other important initiative that we need to go is to implement is ethics training. Now, it may sound a little odd, I suppose, and we could discuss this. What does ethics training mean? Well, it is not a case where we are saying that I can make somebody who is fundamentally immoral and with criminal intent to turn them into a good person, all right? That is the job of priests and imams and so on. That's not, right? What do we mean by ethics training? Well, by ethics training, what we mean is that you introduce people to the important notions which have come out of, emerged in the literature in respect of social psychology over the course of the last 25 years, which explain why people do certain things and how they then engage in a process of ex post justification for what they have done when they have done something wrong. In other words, a lot of people, most people, quite frankly, we have to assume are good people. But you get them, they put themselves in a situation, or they are put in a situation. There's a point at which they suspend all of the things that they know, their training and their values and so on that they are, and they engage in conduct which is wrong. And then what they then do is that they engage in a process of ex post justification of that. Now, if people understand that, and there's a lot of very excellent literature on this that has emerged over the course of the last 20 years, if people understand that, then you can get people to recognize those situations and to be able to, if you recognize the situation that you are in, you should then be able to avoid it. So, Chairman, with that, let me leave it there. And I hope that I have given the meeting sufficient food for thought in respect of this issue. Thank you.